Hi guys, it's Kathy. I hope you're doing well. So today we're moving on to a different topic because the Federal Court of Australia says I'm not allowed to play that Rebel Wilson no more. That's fine. It's not over. So there was no verdict yet. It has not been streaming at all this week. So it's Australia, so it should have streamed Sunday night for us, Monday night for us, nothing at all. So I don't know if it took a week off or I don't know, but it's not live streaming it anymore. So what a shame. Anyway, we'll do a Sov Cit from Judge Fish. That'll make us feel better, right? Here we go.
Your Honor, thank you. This is State of Indiana versus T.R. Butler, cause number 64D012306F65582. Defendant appears in court in person and with counsel, Mr. Steve Pribble. State of Indiana by Gary Gurman.
Okay. Mr. Pribble?
Your Honor, defense is still working with state to resolve this matter. We have not yet been able to do so. That's the status for.
Okay. And then,
Pardon?
what would you like me to do?
Well, Your Honor, I think ultimately this case may go to trial. I'd like the opportunity to speak with Ms. Butler a little more maybe before we set that, but I'll leave that to the courts now.
Okay, Sadie, asking for a jury setting?
I am, Your Honor.
Okay. I want to note a couple things for the record. Ms. Butler, I received a pro se filing from you yesterday.
Mm-hmm.
There were some documents and things mailed to the court.
Mm-hmm.
Do you recall doing that?
Mm-hmm.
You recall sending this to the court?
Mm-hmm. I sent it to the young lady, yes.
Okay, so I am going to scan this, put it up into your file,
Okay.
but I just want to note for the record that
Yes.
we don't permit what's called hybrid representation, okay? So you have counsel, you can't also submit matters on your own behalf. Anything you want to submit to the court, you have to submit through your attorney. Do you understand that?
Mm-hmm. Mm-hmm. Yes,
You do understand that?
yes.
Okay, and then the matters that you submitted aren't matters that we understand in this court. You submitted what we refer to as pseudo-legal jargon or matters that are contractual in nature and have nothing at all to do with a criminal court case. So I'll upload them into the case, but I'm also going to strike them from the record. Okay? Just so you're aware.
Mail that to the clerk. I didn't mail it to, that's private that you have, the documents that you have.
Do you have another case pending somewhere in the court system other than this one?
It's just this case here.
Okay.
Those was private documents. It wasn't for public only.
Is this something you want to file with the clerk?
No, it wasn't filing with the court. No, it wasn't supposed to file with the court. It's supposed to file with the head clerk, Jessica.
And are you trying to file a case or something other than in this case?
It's referring to this case, yes.
Okay, so
Yes.
we'll upload them into the file and strike them from the record, as I mentioned. Let's get a trial on the calendar. Mr. Prosecutor, how many days you need to try this case?
Judge, I believe 2.
And let me say something. Because I'm not being represented and I'm not, my evidence is not being presented like it's supposed to be.
Evidence, as in
Because it's not helping.
not evidence.
How soon can you be ready, State?
Roughly, let's say 60 to 90 days.
Would I be able to say something? Okay.
You've been talking the whole
Brandon
time,
Collins
lady.
going to go? All set trial by jury on August 18th and 19th. So Ms. Butler, I set you over for a jury trial on August 18th and 19th, 2026. If you fail to appear for your jury trial, I'll hold it in your absence and you can be convicted even if you're not present. You understand that?
I comprehend.
We're adjourned.
Your Honor, before we adjourn.
Can you grab the mic?
Before we adjourn, Your
No,
Honor, I know
she
Ms.
said we're
Butler wanted
adjourned.
to
We're
make
done.
a statement if court
No.
would allow that.
No.
Okay, go ahead.
How you doing? The reason why I might have to let Mr. Pribble go because I'm not being helped with my case. There's a lot of violations that happened towards me. There's a lot of my evidence has been tainted, and it's a one-sided case. There's a lot of due process violations that occur, and no one want to listen. Everybody's being selective-minded, and I just want to address that to the court. I have so much evidence that I have presented in this court to show you, to prove to you, show facts, and also show you there's a lot of concealment within this court. So I'm asking you, can you
Concealment.
address somebody to assist me in that matter?
Ma'am, we appointed the Porter County Public Defender Service, I believe, to represent you. Are you in this matter privately, Mr. Pribble?
No, I'm not.
So we appointed the Porter County Public Defender Service to represent you, ma'am. I appoint them and then they appoint a lawyer. So you've got Mr. Pribble involved in the case. You can't pick and choose what lawyer you get when you ask the court to appoint counsel for you. You get what you get.
I get that, sir.
Okay?
But only thing, the reason why I ask is because I feel like I'm not being helped. I see like I can do it myself and present this as pro se, but evidently it's just being delayed continuously.
Well, ma'am, if you want me to do what's called a Feretta hearing and make a determination whether you can represent yourself without counsel, are you prepared to do that?
Yes, I am, sir.
Okay, I mean, I can do that Feretta hearing.
I love his
but
Feretta
I'll
hearings.
let Mr. Pribble go for the day, and I'll hold you until we're completed with the rest of our business. I'm not going to make all these other people wait while I go through a Feretta hearing with you.
Can I come back?
Come back when?
What time is it? Around 12:30?
Oh, no, ma'am. I don't have time at 12:30, but I have time around 11:30. So I'd like to conduct a Feretta hearing. Yeah, I have one here, but I'll use this one. That's fine. Ms. Butler, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. All right. Are you under the influence of any alcohol or drugs today?
No.
All right. Have we set a trial on your case? I was going to get back in the calendar here. Get back in the file, rather. I closed it.
We did, Your Honor.
Oh, that's right. Yeah, we set a trial already. Your trial set for August the 18th and 19th, and you've indicated you want to represent yourself. Did you have a chance to review the pro se waiver rights form I presented you in open court?
I looked at it a little bit.
Did you sign off on that?
No, I did not sign off on it yet.
Okay. Would you like to have more time to review it before you sign it?
Yes. Can I get the second page, please? Because I have written on the back of it. You have
I'll give you a
you have a
whole new-
spare. I'm just gonna give me a whole new one. Can I also address something? You just let me know when I can.
Go ahead.
When we spoke earlier about the document that was submitted, I just want to inform you that the head clerk is aware of it. Since May 11th, they've been working with me, providing me all the accounting. What you just gotten just now, I think one of your staff did not follow the correct procedures. So I was going to let you know that my estate has not been abandoned. I also want to let you know that I did not appoint anyone to administrate my estate. So for that being said, I'm coming here with honor, clean hands, and no conversation. I do not want to argue about anything. I just want it to be settled, closed, and gone.
Okay, ma'am. Anything else?
When you do present another date for me to come in, would I be able to talk about this matter? how this all led up to, because I really never got a chance to even speak to no one. I've been
Ma'am, that's what the
silent.
jury trial's for, okay? All the facts and circumstances related to the case, the state's evidence, everything of that nature would come out during the jury trial. So I need to go through this Feretta hearing with you, ma'am.
Okay,
You've indicated you want to represent yourself at trial. You have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know. Do you understand that?
I comprehend.
Okay. And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty, 2 level 6 felonies. So each one of those would carry between 6 months to 2.5 years in prison. So the total combined penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
I comprehend that as well.
You realize there are factors the court can consider in increasing your sentence within that range or in decreasing your sentence within that range, and that those are called mitigating and aggravating circumstances, and that a trained attorney knows how to identify those and present those to the court?
I comprehend that.
Okay. Attorneys have developed certain skills in investigating your case, interrogating witnesses, and finding favorable witnesses and obtaining their testimony. They can explain the charges and any lesser included offenses to you. They can gather documents and other kinds of written evidence. They can prepare and file motions before trial, such as motions for a speedy trial, motions for discovery, motions to keep unfavorable information from being received as evidence. They know how to examine and cross-examine witnesses at trial. They can recognize objectionable and unfavorable evidence and promptly object to its use. They can present favorable sentencing information and attack unfavorable sentencing information. At a jury trial, they can present favorable opening and closing statements, prepare appropriate written jury instructions, and select a jury. They have the training, knowledge, and skill at properly preserving the record of the case for purposes of an appeal. An attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend that.
Okay. You must understand if you decide not to have an attorney, you will not receive any special treatment with your defense. You have to follow the same rules and procedures in your case as an attorney would have to do. Do you understand that?
Yes, I comprehend that. So,
Okay, so you filed these documents with the court, and these documents make statements about an Office of Executor Observations,
mhm.
findings regarding Porter County Superior Court interaction with Tierra Lene Butler. You talk about final order to settle and close,
Yes.
different things like this. And then
Yes.
there's like a recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or processes that are part of the criminal court proceeding?
Well, I had did some research on my case, and I noticed that I had ended up.
That's not the question I asked.
No.
I think you misunderstood the question.
It's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand
Yes,
that?
yes, I am in a criminal proceeding, But like I've been trying to explain, ever since when I had,
Well, I need you to answer the question I asked you.
Okay.
Okay, which was whether you understand that these documents and things that you filed with the clerk's office, what's the receipt date on this?
it should be April 16 or 15.
April 16th it was received, so just yesterday,
Mhm.
that these aren't criminal matters that you filed with the court?
Those are criminal matters, the violations that have been held against me. Yes, that's a lot of
You
violations.
understand they're not, though. I mean, these aren't things of a criminal nature that would be part of this criminal case.
Well, you saying what I just filed is not what criminal?
This
Explain a little bit
document,
clearer.
these papers seem to indicate that you're trying to proceed in equity or under
Yeah.
some sort of a pseudo-legal jargon, some type of a,
Is we in the Article Court 3 right now?
say again?
Are we in the Article Court 3 right now?
I don't understand what you mean. This is the
Means
Supreme
that,
Court of Porter County.
okay, so we basically still in the same court as administrator. So you're basically trying to administrate a mistake. But I was letting you know.
Okay, Ms. Butler, you understand that these administrative things that you're talking about aren't part of this court proceeding?
I know, I'm aware of that. I was talking to myself. But what I'm saying is I have done some research, okay? And I actually wanted to address it. And I'm not getting no assistance with the public defender, okay?
What are you trying to address, ma'am?
My innocence of the matter, and also the violations, the due process, the unverified information, the lying, the evaluation. I've been forced to be drugged without a cell hearing. My evidence that was held from me when what's his name? Jeffrey Clymer had ordered the prosecutor to meet me in private to see my documents. I mean, the evidence held against me, and he refused to present them to me. That's a Brandy violation because it worked in my favor when I first got it. Then also
Ms.
on the
Butler,
record.
I'm trying to get you through this
Hold on.
Feretta hearing.
I know,
okay?
but you asked me, and I'm trying to explain the violations, okay?
Right, but those aren't violations that are
They are.
part of this court proceeding.
Now, on this court proceeding.
If you have something that you plan to file related to that, it has to be filed through your attorney because you
And
still have attorney.
I did that too. You know what he did?
I don't know, ma'am.
Ignored me.
What you have filed through the clerk's office, you're saying are that matters in equity. We don't recognize what you're talking about in
You
these
asked,
filings.
this is a bank. This is a bank. I understand how the
What'd you
court-
say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system
operates.
doesn't operate like a
Yes,
bank
it
in any way whatsoever.
Hold on, let me finish.
No. I'm not going to let you finish that
Okay.
particular
I
statement.
said I want to
Because
conference.
I
I
just
don't
need-
want to argue.
I need you
anything.
to,
I just want you to
redirect it.
understand me mentally.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay.
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things. You realize that? This is a criminal court.
Yes, it is. This setting is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
Okay, we're an Article 7 court, if you must know, in the state of Indiana, separate judicial branch,
Yes.
not any of the things that you've said here.
Yes.
So what I need you to tell me is
Okay.
whether you are understanding that you have to follow, if you're going to represent yourself, you have to follow all the rules and regulations that are promulgated by the courts of Indiana. You have to follow the criminal rules. You have to follow the trial rules.
Yes.
Will you do that?
Yes. Yes.
You
Yes.
will do that.
Yes.
So you understand that what you filed yesterday can be stricken under the record. Under the trial rules, under Indiana Trial Rule 12F, because it's impertinent to anything that is going on in this proceeding. You realize that?
I understand that in a sense, but like I keep explaining to you, it was not supposed to be filed in the court. That's the difference.
You filed it at the clerk's office.
Yes.
Well, let's carry that out for a
Yes.
minute.
It's a difference.
What's the name of the clerk's office?
The court's office is the clerk of clerks. Clerk of clerks.
Clerk
Yes.
of courts, right? So there are
Yes.
clerks. So if you
Yes.
file something and you have a case pending, they send that to your case. Unless you try to open a case of your own,
No.
you're trying to open litigation of your own.
No.
Okay.
What I am.
This has to be presented in your court case here that you have pending before us.
Okay.
you're
So you
telling
will
us
not
to
strike
follow
it?
the rules.
You won't strike it down, or you will strike
Oh,
it?
it has to be stricken. It is impertinent to anything we're doing here. You understand?
No, I don't understand.
Okay.
How you
You
just
have
strike-
filed documents making commercial demands, demanding accountings,
Yes.
challenging the capitalization. No, you didn't do that, but
Mm-mm.
challenging different things about who you are and who you would in equity
Yes.
minister to,
And for
those
me,
kinds of things. Ma'am, you understand those have no basis in Indiana criminal law.
okay.
You realize
But-
that?
But let me explain. Can I make a statement to you then? You said there's no basis in criminal
Go
law.
ahead. What's your statement?
Well, I also want to say something. And also I am a minister, and I want to read this on the record, okay? And it states that should a man prove himself to be living and not dead, nor loss of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executive. As such, this office gives notice of its authorizations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15. Like I said, I came here with clean hands. And I'm now the executive. My estate has no longer been abandoned. And I don't allow no more trespassing and interloping upon and administrating it. I discovered a lot of things along the way, putting me in this position.
Okay, ma'am. Clean hands is an equitable doctrine. You understand that? This is not a court of equity. If you were in a court of equity, you wouldn't even be given or afforded the right to a jury. I think it's appropriate for me at this time now to terminate the Ferretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendant's utilizing rhetoric of what would typically be called a sovereign citizen movement,
No.
including raising nonsensical
No.
challenges
No,
and attempting to apply commercial law to criminal prosecution
No.
or equitable law.
no, that's not
Ma'am, you
true.
keep saying no, but you're talking over me and I don't appreciate it because I'm trying to rule. The right of self-representation is not a license to abuse the dignity of the courtroom or nor relevant rules of procedure and substantive law. Based on the defendant's filings and her statements in open court finds she's unwilling to comply with rules of procedure and intends to use self-representation solely for deliberate disruption of the proceedings. The request to proceed pro se is denied and appointed counsel will remain on the case. We're adjourned.
Okay. I only found out right before I went live that I couldn't do the Rebel Wilson today. And that was what I had prepared for the next couple days. So, I'm about to play something I have prepared, but I, honest to God, cannot remember if we've already seen it before. I have 2 different clips ready, but I do not know if we've seen it before. So, if you could just let me know where we're watching it, I'll find something else. Prison fight murder. Did we do a prison fight murder? That's what we're going to start with. Oh, I don't hear anything. Hold on. It might just be winding up.
Standing at the podium with Mr. McLaughlin. Mr. McLaughlin, this case is on my calendar today for a show cause hearing. I have a waiver that was signed apparently.
We did not watch this before, but it's long. we're going to go over by like a half hour if I play this clip. Let me see how long the other one is. Not long enough.
Present with counsel, that's Attorney
No,
Birma.
it's not long enough. There's a middle option. I kept 2, I think, clips at the beginning of this because I enjoyed them. I can skip them. I can. All right. Oh, jeez. I'm just going to start it here.
Watch the video. So yes, I had seen it.
And you had charged him with simple battery, is that correct?
Yes, ma'am.
Okay. Do you know how it was indicted?
James, thank you
No,
so
ma'am.
much. I appreciate it.
And what exactly happened? Was it a fist fight? Did he hit him with his fist?
Yes, ma'am.
What you're
Yes, ma'am.
stating? Did you see that yourself?
Yes, ma'am.
Okay, and were you listening to their conversation prior to this?
Yes, ma'am.
Do you know what was said?
No, ma'am. I just do remember it being friendly in nature, right up until I turned around.
And when you turned around, did you hear anything that was said at that point in time?
No, ma'am. I heard a scuffle, and that's what made me turn around to see what was happening.
Okay, you said that Mr. Williams did not provoke Mr. Spires. I believe that was her testimony,
That's correct.
but you don't know what was said, right?
I
You
don't.
turned your back, you don't know what happened.
So it was very briefly. When I walked in, they communicated again, as I don't remember verbatim. It sounded friendly in nature.
Right.
I removed his handcuffs, turned to conduct the paperwork, and then I heard the scuffle immediately after turning. So there wasn't a whole lot of room for communication between the two, but the brief conversation they did have before coming in sounded friendly up until I heard the scuffle and turned around and seen Spires jumping on the victim.
Okay, did you see Mr. Williams doing anything?
He was blocking the hits.
I don't have anything further, thank you.
Anything else?
No, Your Honor, I'd ask this witness be excused.
Very well, sir. You are free to go about your business. Thank you very much. All right, who's next, Ms. Pitts?
I've got some exhibits real quick, Your Honor. Let's see.
I think we did see this before too. You're right. And it's long and it's a lot of prison calls that are hard to listen to. So we're going to move to that other one. Did we do this one? No, we did not.
Present with counsel, that's Attorney Birma.
Wisconsin.
And the state's appearing by either, Attorney Toiber's pointing at Attorney Gramberg. So I'll take that to mean that Attorney Gramberg is appearing on behalf of the state. And we know that we're set for trial next week, likely to start.
Monica. Thanks for the cheers. I appreciate it.
Strike that. We'll start on Monday. I'll ask you, Attorney Birma, where do you want to start for today's proceedings? I think we have a few choices, but
I guess, can we just start with the easy one, like scheduling, like when does the court intend to start for the day?
yes.
That kind of thing, the easy ones.
Yep, 8 a.m. on Monday.
Okay.
Unless you hear something different. Okay, what's next?
And then I believe that the next issue would then be the proposed jury instructions between the state and the defense.
Yeah, I mean, we can take that up today. They're substantially what I expected. I mean, I'm certainly happy to go through those in greater detail, but generally what, I know you had a proposed modified. Let's talk about that. What's your position on that, Attorney Gramberg, that modification to 140?
Judge, the jury instruction by itself is a standard pattern instruction that's been set by the legislature. I don't see that there's any need to modify it.
Attorney Birma?
Yes, Your Honor. Obviously, the court has expressed some concern in Wisconsin about that specific instruction. And all I'm asking is, it's your duty to give the defendant the benefit of every reasonable doubt and stop there.
Mhm.
Or alternatively, you are to give the defendant the benefit of any reasonable doubt that remains after considering all the evidence. So, I mean, I'm not altering the substance of the instruction, but there has been question about that specific instruction and that language that's been raised through the courts. And so I would just be asking for it to end.
But not so much question that the committee has decided to revise and tell all of us trial judges to read something differently.
Right, but also I know that it's also been on their agenda to continue to talk about it.
Who are the committees?
The committees, yes.
Okay.
So we're watching this case because we cannot watch the trial. The trial's too bad. It's a hard case. We don't hear the details in this clip of what happened, and we don't want to. But they want a dog, emotional support dog. I think they're going to have some children in to testify. And they want to have an emotional support dog in. And the defense attorney just does not like that at all.
Let's park that for at least a moment. What else did you have, Attorney Bowman?
So then we have the proposed voir dire and the nature in which voir dire is going to be conducted.
Yeah. You maintaining your objection to the court's questioning?
I do.
Okay, that's noted. Anything else on that?
Yes, Your Honor. I just think that it's imperative that both the state and the defense be allowed to conduct voir dire of the potential jurors, because that's both parties' opportunity to learn about the jurors, learn about any potential bias that any individual juror may have. It's also both parties' ability to interact with those potential jurors and learn from them. And I don't know that jurors would answer questions posed by the court in the same way that they would answer questions posed to the lawyers, because, we hear an answer and then we can ask follow-up questions based on what the answer of any particular juror is. And so I just think that it's imperative that both parties be allowed to interact with those jurors to explore any potential bias, whether it's objective bias, whether it's subjective bias. And I think that by the court asking those questions, that it would be extremely difficult for both sides to be able to identify that based on reading a question, hearing the answer, and then the answer just stands out there. So I think that it's imperative that both parties be allowed to ask questions of the potential jurors.
Okay, I can understand why you think that and are voicing that. Attorney Granberg?
I do agree with that, Judge. It's a little more complicated, I think, than just asking questions and receiving an answers. I would say the majority of the time when we ask a broad question, we like to expand on what the answer is from the jurors. And sometimes other questions come up based on the answer that was elicited from the jurors. So I do also agree and would request that the attorneys be allowed to conduct voir dire.
Well, I'm not suggesting that I'm going to prevent counsel from asking follow-up. I thought I was pretty clear about that. So I'll ask the questions that are on record now, and then you can follow up. You're not going to be allowed to put out hypotheticals.
Mm-hmm.
You're not going to be allowed to integrate defense or plaintiff favorable concepts or ideas. I'm not going to allow repetition. I may apply a specific time in which you have to ask follow-up questions, and it's still possible I'll allow you to ask the questions that are in the record now. So, and, the right to interact with the jury. He has a right, Mr. Hoare has a right to the empanelment of a neutral, attentive, impartial jury. And that's what we're going to test for. And I understand that that's the court's obligation, and I take that very seriously. So with that, and I mean, so if the court asks your questions that are in the record now, or you ask them, and then there's follow-up by the lawyers for sure, that is adherent to what I just said about what I'm not going to allow, then I think we're probably okay, Attorney Bierman.
Well, I guess what I would say, and what I meant by interaction is, observing demeanor, observing body language,
For
things
sure.
of that nature, because it's not just talking to them, it's what else are they doing that they're not saying. And so that's why I was persisting in my objection as it relates to allowing counsel to be able to conduct voir dire. And I understand the court's position, but that's why I think it's so imperative for both sides to be allowed to do that, because to be able to impanel a fair and impartial jury requires both sides to be able to interact with them, to be able to determine in their own analysis who they think those potential jurors are as to whether they can be fair and impartial.
Yeah, but you'll have eyes on them when I'm asking questions, right?
I agree, but I also think that responding to you.
Yeah, that part I don't understand. Why am I, because I'm up here and you're down there?
Well, because you're the authority figure. And so some people react differently to judges than they do lawyers.
Okay.
And I will tell you that, yes, and I'm not saying all jurors, but I'm just saying in my experience with jurors, they see you very differently than they see Attorney Granberg and I. And I don't mean to speak for Attorney Granberg, but they do see us very differently than you.
Okay.
So to you, they're going to say, yes. And whereas with Kristen, or Attorney Granberg and I, I'm sorry, didn't mean to be disrespectful, that, then it's our job to then figure out what that yes means. Are they agreeing to the entirety of the question? Are they agreeing to part of the question? Because obviously jurors have very subjective and objective beliefs. And you may ferret out the objective belief, but I don't know that they're necessarily going to give you the subjective belief. And I think that that's where Attorney Granberg and I need to be able to ask those questions so we can determine through the answers that we receive or the answers that Attorney Granberg receives, that I determine what I need to do with any one potential juror based on those answers.
And you can't expose that potential subjective bias by way of follow-up to the questions that you've already.
I mean, here's what I guess I would say to that. I mean, I think that they're going to give you a very rote answer of yes, no, but then you have the question sitting out there and not immediate follow-up. And so they don't necessarily understand how this all fits together when they're not allowed to ask, or when we're not allowed to ask the follow-up question. Because in theory, this is kind of like a conversation between us and the jurors. And so you hear an answer, and then you may want to follow up on something, or you get a head nod from another juror, and you may want to follow up on what that head nod means. And so that's why I think it's imperative that it's not just the questions posed, it's the responses, and then it's the follow-up as a result of those answers, because they will absolutely answer your questions, Your Honor. But then they just sit out there.
Right.
They don't have context for them. There isn't follow-up simultaneously to understand why that question was asked. And then they're just sitting with it and they don't understand.
I'll mute the parties here. You can ask your questions, but you're going to ask the questions that you
And follow up.
And follow up.
Okay.
Let's make sure we don't have an awkward scene where you ask a question that I consider repetitive or integrating defense or plaintiff favored concepts or ideas. I can elucidate on that if you want me to. But I don't have any compunction about saying, hey, Attorney Bierma, hey, Attorney Granberg, I don't want you to ask that question. I don't really want to do that in front of a panel. I really don't. If it were up to me, I just kind of blend into the court. I think that's especially getting that procedure. Okay, so you can ask, you think a half hour is enough, Attorney Bierma? Do you think maybe 40 minutes?
I was thinking 45. I don't know what the state thinks.
What do you think, Attorney Greenberg?
I think at least 45 is sufficient. And Judge, I would just note, if you wouldn't mind just moving a little closer to the microphone.
Oh,
They
sorry
can't
about
hear
that.
in the gallery.
How about Madam Coordinator, is this okay? Right. Okay. What else, Attorney Bierma?
I believe that, and I'll have the state also, I think all the motions in limine have been decided at this point.
I think so.
And then I would say the other issue is
I'm pretty sure I'm psychic. I'm pretty sure. So I'm getting a submarine and a carrot. Does that belong to anyone in chat? They're showing me a submarine and a carrot. Does that belong to anyone? Think about it. You'll understand it later.
the comfort animal and the location of the comfort animal.
Yeah, that's, there's going to be a comfort animal, and I understand your objection, but there's going to be a comfort animal present. I mean, I'm going to allow for that. I'm not going to get on the phone or call Moose or Hugo and say, hey, what's your Monday look like there, Moose? Make your way over here to C1200. But if somebody from the state is going to arrange for that, I'm not going to stand in the way of it.
I mean, I'm not objecting to the arrangement of it. It's where that animal is going to be.
Oh, I'm sorry. Where do you want the animal to be? Or where do you suggest it not be?
Not in the courtroom.
Oh, no, the animal's going to be allowed in the four corners of this room. So, but your objection is preserved.
I mean, I would like to preserve it further then, that if the potential jury is seeing that animal.
Well, I'm sorry, Attorney Beer, it won't be in here. I'm sorry, it won't be in here during voir dire.
Okay, but I still maintain my objection about the animal being in here during testimony, because again, that potentially is unfairly prejudicial to the defendant because the jury is potentially drawing inferences from that animal being present. And it's only being offered to specific people within the process. It's not being offered for the forensic interviewer. It's not being offered for the law enforcement officer. It's being offered for very specific people. And I think that a jury could draw some very negative inferences based in fact on who it's being offered for, it being in the courtroom, and any conclusions that they draw from the animal being in the courtroom. Whereas there are other options where the animal could be in one of the conference rooms right off the courtroom. So in the event that someone needs the comfort animal, that it's still available, but it doesn't prejudice the jury by sitting in the courtroom.
Yeah, I don't know. I can't eradicate every form and scintilla of potential inference. And this isn't really very unorthodox. I understand your objection, Attorney Bierma. And now that I think about it, I suppose the support animal could be here for all witnesses. But I should hear from Attorney Granberg. Attorney Granberg?
Judge, that was actually going to be my solution, is the state can have Moose sit with every one of their witnesses, and I have no problem with that.
Okay. Attorney Bierma?
Is it going to sit through defense witnesses?
Attorney Granberg?
I would have to speak with them. I'm not sure exactly what their protocol is with having people that are not familiar with the state and not called and pre-screened, for lack of a better word.
Well, you let the file know, Attorney Granberg. You think you can do that by Friday at noon?
Sure.
Okay. So the result there, Attorney Bierma, the support animal, sounds like Moose, is going to be permitted per or by way of arrangement by the DA's office, and for sure he can be present for near and about the statutory victim during testimony. But we may, I almost use the word probably, but we may expand on that and expect to see him present with any witness. And yeah. Is that sufficient for now, Attorney Burma, or would you like some more clarity?
I mean, I persist in my objection because I think that Moose being in the courtroom near the statutory victim is going to be the issue. I don't have a problem with the animal potentially being present if the animal is in the gallery, but I do persist in the court or the animal being in the well of the courtroom.
Okay.
Because while it may not be unorthodox in the court's conclusions, but I can tell you that courts also are concerned about the optics of that and how a jury receives.
It's Wisconsin, so maybe it is a moose, an actual moose, and we just think it's a dog.
Or interprets that when they see a comfort animal near the complaining witness.
Yep, I understand. I mean, I know there's concern. It would be weird if there wasn't at least mild concern, but
maybe it's a moose named dog.
These support comfort animals are becoming almost, I wouldn't say ubiquitous, but they're very common in high stress environments. You see them at airports, you see them in hospitals, you see it where people are, and not just statutory victims, people are just tightly spun and stressed out and unsure of what they're going to experience. And courtrooms and courthouses are, they're high stress environments. I mean, I can say something like that if you want, Attorney Birma. I can do something curative, but I'm very open to that. Ladies and gentlemen of the jury, don't draw any inferences. We brought a service animal here for the for the comfort of all present and convene, something like that. You can use that if you want.
Well, I guess I'd wait to see what the state says, because if it's only the state side of things, then.
Yeah, well, right. Attorney Granberg, anything else on that? And actually, Attorney Granberg, why don't you turn around that communication sooner than Friday? Can you confirm by tomorrow at noon whether Moose's handlers will permit him to be close to any witness?
Judge, could I at least have till the end of the day? I don't know what the handlers' schedules are like. I would say just for the record that the primary purpose of Canine Moose is for children victims. So it is a little unorthodox to have it with any of the other ones. I do think the court's suggestion of a curative instruction that says any one of the individuals who are testifying were given the opportunity to have Moose there and they could decline or not. Obviously, that would be subject to the availability of the handlers.
Yeah, but I don't want to be completely inconsiderate of what Attorney Birma says, because there's something there. So you check on that by 4:00. Let everybody know by 4:00 tomorrow, please, Attorney Granberg.
I can do that.
Dividing my attention here. I'm still thinking about that modification to 140. But what else did you have, Attorney Birma?
The timing of the release of the potential jury list.
Our clerk of courts here is present in the gallery. Deputy Clerk, would you let... Yeah. Good morning, Cindy. Do you know anything about that?
Yes, Judge. Currently, we still have a jury scheduled this week, Friday, so we would need to pull that panel first. So with our current arrangement, we could have this panel ready by 4:00 on Thursday.
Okay. There you go, Attorney Birma.
Thank you.
Cindy, do you want me to reinforce this expectation that you get all those original materials back as soon as, when do you want the return to you, so you're not chasing it down, those voir dire list?
We have counsel or staff on their behalf sign an acknowledgement that they'll do that by the end of the appeal period, post-trial.
Oh, yeah, I forgot we established that policy. Okay, thanks. Appreciate that. No taking will be allowed, no juror questions. I'm going to sit three alternates. And Cindy, any reason, or Dana, any reason to?
I think I will volunteer as the moose tester and test Moose out to see if he can handle a severe level of crazy before the trial. I'll bring it upon myself to do that.
I think the three is it 4 strikes aside, Attorney Birma, or is this 5? 5 aside. Okay. So, yeah, Cindy,
Our only concern is that we'll have to move some furniture, but we'll make that happen before trial.
okay, but access to that number of humans is
We're fine.
within reach. Okay, thank you. So 5. So what do we have to have in the box, Attorney Birma?
You have to have 12 in the box, and well, I don't know where you're going to put the 3 alternates though.
Yeah, we'll find a place. But how many to come down to 15 do we have to have in the box to start out on Monday morning?
25.
25.
25?
At least.
Well,
I mean, that's presuming
25
5
in the
and
box,
5.
and then there'll be folks in
Right, and then folks in the back, yes.
the gallery. So, okay. Anything else, Attorney Birma?
Other than the 140?
Yeah, other than that 140.
I don't believe so.
I want to think about that just a little bit more, please. Anything else? Attorney Gramberg, anything from the state's perspective?
I don't think so, Judge. I think Attorney Birma covered it all.
Okay, and I appreciate the reminder about my voice projecting back there. I think.
Oh, I have one other thing.
Yeah,
Sorry.
Attorney Birma.
Sorry. Does the court stream the entirety of the trial?
Well, I'm glad you brought that up. If I said yes, what would you say to that, Attorney Birma?
I would object to that because of the attorney-client relationship and the attorney-client privilege, because it would potentially detect any conversations between Mr. Hoare and myself.
Oh, so I've been
And that's
breaching
also-
I've been breaching that privilege for the last 7.5 years. I better stop that. I mean, you do have to make efforts, Attorney Birma, we're
I
at a
love
very
this,
technological
Judge.
age, and so I mean,
it's that, but it's also alleged victim identification, it's witness identification that are not law enforcement. I mean, it's all of it.
well, and the state raised something, I don't know, 2 or 3 or 4 weeks ago or longer, where there is I think it was a viable concern too, especially during trials and during the voir dire process, where there's the possibility that folks are, on a mobile device or something else, and they can actually, they have access to the courtroom, and we don't want them to have it. So I'll turn off live streaming.
Thank you.
Is that okay, Attorney Gramberg?
That is fine, Judge.
Is that actually your preference?
Yes.
No, Attorney Gramberg. I'm
Oh,
asking.
sorry.
Yes, Judge.
Okay. All right. No live streaming. Ashley, please remind me of that.
I didn't want it anyway, Judge.
She's not here.
So,
She's
there.
listening. No, she's not. She's not here today. Jean. Anything else, Attorney Birma?
I don't believe so. Thank you.
Attorney Gramberg, anything else?
Terry O'Banion.
Just to supplement the record on the live stream issue, I do think that the court's determination that it's not going to be live stream is also beneficial to the victims and their identities and whatnot. So I do think that's more than appropriate, and I appreciate the court taking that into consideration.
Absolutely. It's that tension between being an open book with very public proceedings, with some exceptions where I would turn live streaming off, and some sensitivity, especially in, some of the subject matter here. So I think that's a good result. No live streaming. Anything else, Madam Clerk?
No, Your Honor.
Okay, recess. Thank you.
Thank you.
So, Erica.
All right, I made 2 more clips. while we were watching that. So we're good, guys. The stream is fine.
Just so that because the back tables, you can see the entire panel.
This one's first.
Daniel Barnes versus the state of Indiana. Mr. Barnes, can you hear me?
Yes.
Great. And
Yes.
sir, can you please state your full legal name for the record?
It's Albert Daniel Burns.
Thank you. And this is cause number 1806 PC 36. Sir, can you please raise your right hand? Do you swear solemnly affirm to tell the truth, the whole truth, and nothing but the truth in the cause before the court? If so, please say I do.
I do.
Thank you. And sir, you're currently housed at which correctional facility?
Wabash Valley.
And what is your date of
I
birth?
do too.
December 19th, 1973.
And the last four digits of your social security number?
6705.
That's what happens when I rush it. I rush this clip
All
out,
right.
and that's what happens.
It looks like we're here for a status conference. You may not have received, looks like you filed a motion for appointment of counsel outside the ranks of the public
I did.
defender's office.
Maiko. It's an emotional support hat. Leave him alone, bully.
Which the court
My
denied
coffee's here. I'll be
because
right back.
basically the court appoints the public defender's office and they get to pick who they want to represent the client. And I do not appoint outside counsel. If you want an attorney other than what is provided by the state public defender's office, then you're going to have to hire your own attorney. So where are we at?
Well, I guess I'd like to object to that because it's my understanding. I mean, I'm no expert in the law, but based on my understanding, it's up to the discretion of the court to make that decision and not the attorney. And as a matter of fact, I just looked at one of your cases here. It just popped up on Lexis, that Abbott v. State, and I was not aware of this statute, but it cites statute 3410-1-2, where Mr. Abbott requested counsel. And you have, based on my understanding, you have the discretion to decide who's appointed counsel. And there's two.
And Mr. Barnes, I'm telling you that my discretion is being used, that I am appointing the state public defender's office and they decide who. I am not in the business of running any other office but Superior Court number 3. So.
Right. Well, this is your case though, Your Honor. This is in your courtroom. I'm under your jurisdiction, right?
Correct, but I believe the case is it another post-conviction relief case?
No, it's a civil case, like a post-conviction case is a civil case.
It's quasi-civil, quasi-criminal.
Yeah,
So,
but in my opinion, that should be even more discretion because this is a matter
Mr.
of
Barnes,
liberty.
I'm not going to, Mr. Barnes, I'm not going to argue with you. So
Okay, that's fine, Your Honor.
then you'll reach it and you'll receive it in writing. If you want to appeal it, appeal it. So
Okay.
what I'm asking you is how you wish to proceed.
Well, I'm going to stop it. I will still keep fighting the case. You know, I mean, it's,
Okay. So you want to proceed?
it just, you're right. I'm going to have to, but it just, Your Honor, you saw the pleadings. Does this look like some sort of frivolous claim I'm making here? I mean,
Mr. Barnes?
the statute's ambiguous. Yes.
Mr. Barnes, I'm going to mute you in a second if you keep talking over me. So I've given you my decision. If you don't like it, you can proceed however you wish to proceed. But today, I want to know, so you're going to proceed pro se. How much time do you need to prepare for your case?
Well, I'd like to appeal this decision. I mean, did you certify this order, Your Honor? I'm not even.
It's an order. It's an order that was issued by the court today. So it should come to you. I'm not sure how quickly things proceed with the Indiana Department of Corrections, you can read it and proceed however you'd like. So.
Okay, but I guess what I'm asking you is that order certified?
Something
And that would
should be
technically be a
certified.
legal
It's not
opinion,
the
and it
order.
depends on what you consider certification, and the court cannot practice law. So everybody uses terms differently. It's an order signed by me, yes, and it is stamped by the clerk.
All right, so I'm going to file an interlocutory appeal.
And sir, again,
Not sure, Kobe.
Mr. Barnes, I'm
But the
gonna
only
mute
reason-
you.
Well,
So
may I
anything that
just
you
say one thing,
say,
Your Honor?
I won't be able to hear, So what I'm going to tell you is that I'm gonna reset this for, let's see, when I have availability. I'm gonna reset this for July 30th, 2026 at 1:30 p.m. for a status. At that time, you're gonna let me know if you're ready to proceed to trial, or if you need additional time, or if you've researched attorneys, whatever it is you wish to do. I am now going to unmute you and allow you to say if July 30th is enough time for you to figure out what you're doing. Unmute.
Yes, Your Honor. I
right.
apologize if you thought I was talking over you. I didn't mean to do that. But
So-
I just have may I ask the court one question, please?
Again, I can't give you legal advice.
Okay,
So-
I don't think it's legal advice, but I just want to state on the record that I hope that this is not considered by the court as me delaying things. I'm trying to move as quickly as possible here. And if the order is not certified and I have to do all this research and it turns out that that's going to cause even more of a waste of time, I let the record show that I am trying to pursue this as diligently as possible, as I have been doing for the past 10 years. This is becoming ridiculous. I mean, I've worked so hard to make that thing.
Wait, what? Has this been going on for 10 years? There's no way. There's no way this judge has a 10-year-old case open on her docket. There's just no way, unless he absconded for 10 years or maybe he's incarcerated for something else, like federal or something, for 10 years, and now they're coming back to do this. Look, I know this judge. There's no way she has a 10-year-old case open on her docket. And maybe I'm wrong, but I think it's the first time we get to see Teresa in the new courtroom. Unless they change the camera angles so drastically, but I think she's in the new courtroom, which is kind of weird based on the chairs that I saw.
As crystal clear as possible, and it's probably not accurate from a legal standpoint. I understand that. That's why I need legal help. All my money's gone. I gave it all to, the state took everything from me. I have nothing. I'm fighting for my life here. And I'm sorry, Your Honor, but I mean, when this thing came to trial back in 2016, I had funds. I paid my own attorney. The state didn't pay 1 cent for my defense back in 2016. I didn't make them spend money on a public defender. Now you can see by the claim I raised in this petition that this is not some frivolous joke here. I'm raising solid grounds, and I feel like I should be entitled to some assistance here by somebody who knows how to navigate this. That is not me. I am not an attorney. And here I am sitting in prison for something I did not do and frankly wasn't even charged with. Okay? And I'm sorry, but this is becoming ridiculous. And I don't mean to sound disrespectful. I hope that's not coming off that way, Your Honor. But
Well,
I have my wits end here. And
and they reviewed your case and they have withdrawn. So.
And I'd like to say one other thing about that. This is the same lady, Tracy Nelson. Look up Madden v. State. There's a man who pled guilty to a charge that he knowingly shot someone in the head. He claimed he didn't know what the word knowingly meant. She goes to bat for this guy. I'm raising a solid claim, and I'm backing it up with the dictionary, for crying out loud. And
again,
Mr. Barnes, there's no merit.
Mr. Barnes.
I'm sorry, Your Honor. I'm sorry.
I'm not here to argue.
I don't mean to sound. I'm passionate about this. My life's at stake.
I understand that, but you understand I have a job to do, and if you're unhappy with the representation that you received from the Indiana State Public Defender's Office, I suggest you write them. Because I have no control over any attorney, and that would be
Maybe that's why I thought he was super sexy, Kova.
the Indiana Supreme Court, that we're all licensed. So.
Right. And as you saw, when I sent that last motion, I did write to them. They didn't even respond to me. You ordered them to represent me. You said you read the pleading, you told them to represent me, and they defied what you said, and then just left me hanging without even the benefit of answering my letter. This is what we're dealing with here.
Mr. Barnes, I can't give you legal advice. So I suggest that you either contact a licensed practicing attorney for the state of Indiana. But I will see you.
I'm just okay.
I'll see you on July 30th, 2026 at 1:30 p.m. Unless Wabash Valley has something going on, then it'll either go a week up or a week down. Okay?
Well, just keep in mind, I plan on appealing this, so I don't know how that's going to affect that date or not, just so you know.
I'm not going to I only deal with stuff that's filed, and I will deal with that if and when it comes. All right, thank you.
Okay, Ron. All right, thank you.
Thank you.
Okay.
And then we have.
I found another clip while we were doing that. While we were watching that.
Cause number 1706.
Court dog. Don't worry. Oh, how long is this clip? I have no idea.
Good morning. Morning, Your Honor. I have Terry O'Banion.
14 minutes. So much, that's what's left. Unless I mute and talk a lot.
Is State versus, Terry O'Banion, 2512 F6 1177, 2603 F6 209. Mr. O'Banion is in custody in court with his attorney, Mr.
You should celebrate your birthday here, James. I might have a really good clip for you.
Norris, State by DPA Soto. All right, both matters are set for record today with a trial of April 23rd. You did file a motion, Mr. Norris, seeking competency determination. Is that correct, sir? That is accurate, Your Honor. All right, that's based on your conversations with Mr. O'Banion as well as the filings. Is that correct? That's correct, Your Honor. All right. State, I don't know if you really have a
I'm sorry, Judge.
I don't really know if you have a dog in this fight, right?
You're not.
Speaking of dog,
All right,
Judge.
so if we do that, we have to vacate the trial date, Mr. Norris, because we're not going to get an assessment done in time. I understand. I don't. Sorry? I don't. Can I get a new counsel? No, I do not appoint specific counsel, Mr. O'Banion. Mm-hmm. So all my motions that I filed are denied. This dude ain't done nothing for me since. All you gotta do is look at my phone and get all the evidence and get the case dismissed. I know the people wrote multiple letters to you, to the courts, and to the recant statements to victim advocate unit. I'm innocent. Y'all know I'm innocent. He knows I'm innocent. Look at him. Yeah, y'all know I'm innocent, bro.
I'm pretty sure you're innocent.
Everything filed, you know I'm innocent. I don't know anything about your cases, sir. You know, you got the letters. You know, if you suppress all the evidence, is right there. You got my phone. They took that for evidence. He ain't trying to show me no evidence. He just want to sit here and try to get all because I didn't sign a time served plea, bro. That's all a misdemeanor, bro. All right, you calling me bro? No, him, because he knows he's lying. All right, you're not going to call him bro either. Okay, yeah, you're right. I'm an inmate. That's what he told me yesterday. I did not. You did. No. Yes, you did. Okay, Mr. Bennett. We're not going to have conversations between you and your attorney here, okay? Right. Conversations between you and your attorney are privileged. I'm violating all my rights. We are broadcasting this. Yeah, I want all transcripts too. Are you done talking? No, I am. It's going to be my turn to talk. Are you done? Yes or no? I've asked you a question. Are you done talking or not? I said I was. I said, yeah. I said I am. All right. Mr. Bannion, the court appoints the public defender's office. It does not appoint particular counsel. The counsel that has been appointed to your case is Mr. Norris. You are, of course, always free to hire counsel of your own choosing.
For the law, right?
I'm sorry?
For my rights and laws, like this is what he's for the law, my 6th, 7th Amendment rights and all that.
Yes, that is the law. You can hire counsel of your own choosing if you have the ability. If you don't, the court appoints counsel, and the court has done that. Now, Mr. Norris is.
I'm just wondering. All right, he gives the attorney that look, and the attorney punches him right in the throat right now. How much time does the attorney actually get? And does he get disbarred? I mean, if you punched your client, would you get disbarred, or is that just a slap on the wrist?
Filed this motion.
What is it? What's the file?
The motion is to have you talk to a doctor.
A doctor?
Yes.
About the law?
Not about the law,
About
sir.
your competency. We discussed that yesterday.
So the evidence on my phone where I recorded the whole situation.
I don't know what's on your phone.
Yeah, he does. They do. It's just evidence. He knows that. There's no evidence. The evidence is someone made a statement on me on a misdemeanor trespass, and he's trying to say I need a mental evaluation over a trespass.
Well, both of these cases are felonies, so I don't know.
No, they're not, sir. They're making you think that. They know it's only a misdemeanor.
Okay, I asked you earlier if you were done talking.
He brought me a
Seems
time
like
served
you're
plea,
not.
bro. Show him the pleas you brought me.
I didn't bring you pleas yesterday. I don't.
But you still got them, don't you? The time served plea? Oh. I mean, I'm not trying to offend nobody in here, but come on now. It's the law. They're trying to, serpent, snakes, whatever it is, bro. You want some snaky stuff, bro?
Okay.
You know that.
All right, Mr. Bannion. I've asked you once before. I'm not going to ask you again.
Mental evaluation. Okay. Now, do I gotta wait for someone to come talk to me, or I gotta go somewhere?
Now you have to wait for someone to come talk to you, sir.
So they're gonna come talk to me, and what do you think they're gonna say?
I don't know. You're going to have that conversation with them. I'm not a doctor.
Are
I can tell you
they
that.
gonna get they're gonna get the police reports, they're gonna get the evidence and all that too? Because I don't understand what a
Yes,
mental
the
evaluation will do with this
I've got the
criminal case.
evidence. You've never asked me for your discovery. I'll provide that. I'll send that to the jail.
Bro, what do you think this is, bro? This isn't suppressed all evidence. These are all the motions.
All right.
I've been asking you, bro. You're a liar, bro.
Vacate the
You could do a
April 23rd
deposition. How
trial
about that?
dates in both cases of an appointed doctor. We're going to reset the
You did that on
status
purpose, bro.
April 23rd at 9 a.m.
So when's the next trial date?
Delay under criminal rule 4 is to the defendant.
Can I get a jury, fast speed jury trial? That's not right, 6th or 7th minute right now. I filed for that too.
Well, Mr. Bannion, I've already told you I don't accept filings by you because you have an attorney.
Or him either, right? Because he don't do it.
All right. Anything else, Mr. Norris?
No.
State?
No, Judge.
All right, Mr. Bannion, we'll bring you back to court on the 23rd at 9 a.m.
Is it gonna be for my jury trial? No?
It's not.
You're gonna deny that, of course.
Casey White?
Casey White.
This is State versus Casey White, 2501 F695. Casey White.
I'm going to let this play, but that's all I got for today. Just so you know, that's what we have for today. This has 8 more minutes. I'm just going to let it play. But I don't know. There's often cases that you are not supposed to see because they're not, and it's every day. So I don't know if she did anything that bad that you aren't supposed to see it. I don't know if he says her address or her phone number or email or social security number. I don't know. We're just gonna watch the court docket and with our fingers crossed.
Casey White. Casey White. Casey White is not here. Mr. Norris is here. State by DPA.
He absolutely did, man.
Set for sentence
Yes.
today. Have you had contact with Miss White, Mr. Norris?
Your Honor, I think last time we were continued because she was inpatient somewhere. I have not, but I do have her mother's phone number. I would just like one opportunity to try to make sure that she's not inpatient somewhere. I don't want her to have a warrant pop up if she's in treatment, Your Honor.
Well, here's what we can do. I can issue the warrant. If she's in treatment, you can get me verification and I'll vacate the warrant.
Understood, Judge.
I think one of the issues I have in the plea
is that Miss White was given misdemeanor treatment in Elkhart Superior Court Cause 2506 F6 614 on November 25th of 2025.
I did see that in the
So
PSA.
she's not eligible for future misdemeanor treatment in this case. So that's going to be, I guess, a matter that needs to be discussed with Miss White.
Yeah, sure.
All right. When she was here on March 5th and entered the plea, I set sentencing for today. She is not here. It's 9:20. Court issues warrant. If you have documentation, Mr. Norris, you can file that confidentially and I'll vacate the warrant, sir.
Thank you, Judge. That's all I
Mr.
have.
Norris, anything else?
No, Your Honor.
I should ask you, Ms. Soto, anything from you?
Okay, looks like there's 5 more minutes left in this. All right, now listen. We can move on to a different docket next that I have not watched, okay? Here are our options. Here's what I have ready. I have Georgia. I don't know who the judge is, though. It's Telfair. I have Bleckley. That's Georgia, too. I have the 184th, which is the Judge Kathy, all right, in Texas. It sort of looks like Judge Fleischer's courtroom, and we never get to see her. Judge Funk, who's a lot like the judge we're watching right now, Francisco. Pretty similar. Jeffrey Thorne is like Judge Claimer. Tammy Stokes is Georgia, but she's more north, so there's no accent. I have Judge Fish. The 2 days before that Sov Cit we saw at the beginning, I have him ready. I have more from Wisconsin, that judge. So we can pick one of those. I have more, but you guys don't know that. You guys won't. I have another one from this judge if we like this judge. So, those are our options. If you guys don't pick anything, I'm going to go with Judge Fish from the day before.
No, Judge. I'd pipe up if I need some.
Mr. Dahlquist, good morning, sir.
Good morning, Your Honor. I have Mr. Martinez Gallardo.
State versus Raymond Martinez Gallardo, 2601 F61. Mr. Martinez Gallardo appears in court at Liberty with Mr. Dahlquist, state by DPA Soto. Mr. Dahlquist, this is a record date with a trial of April 30. Are we confirming that this morning, sir?
Your Honor, I would ask that we vacate that trial date. I think the first thing is I have another trial, a jury trial set that day. And I know I'm far, far down the list on that. This would likely be down there with that. The other thing is that I do have a plea that we've worked on. However, there has been some recent life changes for Mr. Martinez Gallardo that necessitate me going back and trying to modify a few terms. I expect that if we can maintain that date of the 30th, I think we can use that as a change of plea date.
Ms. Soto, any objection from the state?
No, Judge.
And Mr. Martinez Gallardo, is that what you want me to do, sir?
Yes, sir.
All right. On motion to defend it without objection, the April 30th trial date is vacated. Sir, I'm going to reset this for status on April 30th at 9 a.m. Do you acknowledge that to be your next court date, sir?
Yes.
You understand if you're not here, I'm going to issue a warrant for your arrest.
Yes, sir.
Make sure you stay in touch with your attorney. It sounds like he's working to resolve this case
Yeah,
based on some changes in your circumstance. Delay under criminal four is to the defendant. Mr. Dahlquist, anything else on this case, sir?
Your Honor, if you'd be so inclined to issue a community corrections evaluation with MCC.
Usually I do that after the plea.
Understood, Your Honor.
So I don't think there's any reason to do that now. Do you live in Elkhart County or St. Joe County? Where do you live, sir?
Currently, Mr. Martinez Gallardo has accepted a job offer in South Carolina, which is why.
Okay, well, however this case is resolved, it sounds like maybe community corrections in
It's
this
not.
community is probably not where he wants to be, right?
Right.
All right, so I'll hold off on that, but we can revisit that issue when it becomes right. All right, Mr. Martinez Gallardo, we'll see you April 30th at 9 a.m., sir. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor. All you had this morning, sir?
Yes, Your Honor.
Have a nice day.
You as well, and a happy Easter.
You too, sir. Mr. Niedzgotsky, good morning.
Morning, Judge. Shamar Dove.
All right, this is State versus Shamar Dove, 2105 F6 465, 2601 F6.
All right, we're moving to Michael Fish. We're looking for Kevin Conger. I'm gonna find him. All right, supposedly he's sort of in the middle. So about here. Let's see, that looks like him, doesn't it? Did we see him before? There's no sound yet. Hold on, he'll unmute it in a second.
For me now, with everything that happened last time, that's all.
I don't think your mom's here today.
We saw him before.
Checking the.
We saw this before, so I'm gonna go to protection order. Oh, it's a 4-hour docket. Oh, jeez. I'm guessing it's that right there.
Think of the words, I'm so sorry.
Take your time, ma'am. I don't want you to feel like it's a stressful situation. I just need you to take your time and tell me what's going on.
I just want to be at peace when I'm at my own home.
Okay.
I can't even walk outside without fear of, him being outside. I can't even go outside and push my son on the swing. It makes my mom feel like she's at fear for her life when she's there watching my son.
Sure.
Because I
yeah.
work 40 some hours a week.
Right, but I can't really take into consideration how
Right.
it makes your mom feel. What I'm concerned about is how it makes you feel.
Right. I'm really worried about my son more than ever.
Okay. What are you worried about specifically?
I just don't need my son seeing those types of behaviors. I grew up seeing those behaviors growing up, but I don't want my son to see those types of behaviors.
Sorry you guys are having a sucky day.
All right, and then you have another incident from March 28th of 2025. I believe it's 2025. And on this one, you say that he stopped at your house, banging on the door, trying to get in, yelling. What's that one about?
I had borrowed him $20 and he was coming to collect it was before I would even get the check. And then he was screaming obscene names and calling me out of my name in through my window from the side of my home.
He was trying to get his $20 back?
Yeah.
Okay, what time of night was this?
It was early in the morning. I want to say around 7, 8 o'clock in the morning before I would even go collect my check.
Okay. Anything else go on during that incident?
I called the cops afterwards after I heard him screaming. I was asleep in my bed when I heard the screaming.
And did the police come through?
Yes, they made a report. There's reports included in all of the paperwork.
Did you get,
Yes.
did you answer the door?
No.
Did anyone?
No.
Okay.
Everybody was sleeping in my home. If that tells you how early it was.
Well, it doesn't tell me much because people sleep at all different times of day. So
Right.
I don't know that that's incredibly helpful.
Thank you, Judge. Thank you.
Deciding that the point was between 7 or to 8 a.m.
Yes.
is the best evidence there. And then you have February 22nd, 2026. This one says that Mr. Hughes blocked my mother in driveway and would not let her out.
So me and my girlfriend, we had went out for a day out and our cars were in the driveway. My mom couldn't get in the driveway to park. So she had parked in the driveway next door, was coming to get me so I could move. And Dennis pulled behind her and blocked her in. And I tapped on his window and I said, can we please be adult? Can we please just move out of her way? And he turned his head.
Okay, so you were there.
I walked out of my home and I asked him, I said, can we please just move? Like,
Okay.
just be done with this. Why are we doing this?
How was he able to block your mother in the driveway?
The driveway is long like this. There's an incline with a big hill going up to the side of the house. And then there's a little bit of a downcline and there's a big chunk of wood and it lines the driveway. She had pulled in and he pulled in. So she pulled in this way in the driveway. And then he pulled in like this behind her and would not let her get out of the driveway.
Do you all share a driveway or something?
No, she had parked over there so she could come get me, so I could move my vehicle, so she could park in the driveway.
So she was parked in his driveway?
It's not even his. It's not his home. It's his girlfriend's home, if that's what you want to call it, yes.
But your mom was parked on a driveway, not her driveway or your driveway.
No, but it's really no one's driveway. Nobody owns it. The owner of the home lives in Texas.
Well, somebody owns it.
The owner of home lives in Texas.
So a few minutes ago, you mentioned something about another protective order proceeding. Do you have a protective order, or I'm sorry, does Dennis have a protective order against you?
Yes.
Okay.
But if you read in one of the reports, one of the officers says that he is clearly trying to get me to violate this protection order to get me in trouble.
Well,
That's what it seems like from the police's perspective.
let me ask you more of, and I have to make the decision about this case on my own. I can't use a police officer's opinion about what Mr. Hughes may or may not be doing in that regard, because that would be what we call speculative. So that doesn't help me, but who lives at 1602?
Me and my mother stays there because she watches my son.
And how's 1630 situated with 1602?
When the owner moved from there, he had rented it to
No, how's it situated? Is it right next door?
right next door.
Okay, but there's a separate driveway for it?
There's two separate driveways for the 1630, and I have a small driveway, a very small gravel driveway.
Okay.
She was so evasive about just saying that that was his driveway, because it's his driveway, that I don't know if I believe a lot of what she's saying now. But Rebel Wilson may have traumatized me.
You had submitted some documents, about 31 pages of documents along with your petition. I do see here how there's a map attached.
A what?
Looks like there's a map here. A Town of Pines and Vert Discount Liquors, is that in your area?
Yeah, that's right by my home.
Okay. I guess it doesn't really tell me a whole
Whoa,
lot.
whoa, whoa, whoa. Judge, go back to that. Discount liquors? Discount liquors? Can you ask her more questions about that?
Map that doesn't show the precise locations of the driveway, it just shows the general location.
Are they the pictures with the date?
In Pennsylvania, we have liquor stores that are owned by the state. So it's slowly changing, but the only way for us to get any kind of liquor is to go to a state-run liquor store. So there's no such thing as discount liquors. Now, they're starting to sell beers and wines in like grocery stores. That's new to us. We can go right into even a Wawa, and we can get like a hard iced tea or a beer. Now, that's really, really new to us. So states that don't have state-run liquor stores, they have these discount liquor stores, which I'm really jealous of. I'm sure they're not really discount liquor stores. I'm sure they charge the same amount.
It's in the times on the bottom of them.
No. No, this one has like an X and the word
Oh,
home.
okay. I don't know how that got into this,
It
but
says like,
that's just to show the situation of how close the homes are to one another.
right. That's what I assumed from it. And then are you asking me to take these police reports into evidence?
That's what they ultimately are, yes. Just as evidence and witness statements.
Okay. Mr. Hughes, do you have any objection to me putting the police reports that are attached to this petition into evidence?
Objection hearsay. Just say that. Objection hearsay.
Sure, I don't,
You don't feel like you have an objection?
they're allegations.
Okay.
Objection.
All right. I mean, they're not, do you have copies of them in front of you?
Mm-hmm. Can I show them?
Say again?
Can I give them to her to show to him if he
You
wants
also
to?
have some handwritten notes there. What's that about?
Those are the witness statements from a girl who used to live with me, who was also.
Oh,
a
hearsay
Quincy's legal-
statements?
Or Dennis, sorry.
Okay.
And then another one also.
I just need you to know that we have rules of evidence here.
Okay, I
And
didn't know.
like my rules of evidence say I can't take a letter from somebody,
Okay.
you know? I mean, Dennis could agree to let me read the letter, but even then, even if I do that, because he's pro se, like, I feel like I have a duty to the process to not consider hearsay evidence. The police reports would be considered hearsay evidence as well. So you don't have these people here to testify on your behalf?
My mother.
Your mother is here?
Mm-hmm.
She wants to come testify?
Yes.
Okay. You want to get mom for me?
My friends tried to, but they weren't able to make it today, so
I understand.
that's why they ended up writing statements instead, because they were sick.
I don't think I can buy beer or whiskey in Walmart here. I also don't think I can buy a gun in Walmart anymore. I could be wrong on that. But I think they took all the guns out of Walmart, which is weird.
Got a rail right there too if you need it. Well, before you sit down, please stand and face me. Raise your hand to be sworn. Do you swear from under penalty of perjury to tell the whole truth, nothing but the truth? Okay, thanks, and please be seated.
I normally bump up the volume a couple times on these videos before I show them, and I wasn't able to on this one, so that's why it's so quiet.
So you can be talking into the microphone. Thank you. And can you state your name for me?
Elizabeth L. Bowen.
Okay, I need you to pull yourself all the way to the microphone because you're going to talk light like that. There's no way we can hear you.
Okay.
Okay, tell me your name again.
Elizabeth L. Bowen.
Okay, is Elizabeth L. Bowen? All right. And then your daughter's going to ask you some questions.
I just want you to be able to explain to the judge, because these are just technically hearsay, kind of what's been going on also when I'm at the home versus when I'm not at the home, even with you and Jellen.
I'm afraid to get Dylan on and off the bus because of the person keeps driving by and coming next door, but he's in fear for his life. And he thinks it's okay to roll down his window and say inappropriate gestures in front of a 6-year-old. And I can't do this. I really can't.
Ma'am, do you live at that house?
Yes,
Your mom lives with you?
Basically, yes.
Well, basically, or she does?
She
I'm a
does.
caregiver for my grandson because my daughter's always working.
Is her address on your driver's license?
No.
Is her address on your tax return?
I don't have-
Terry, I'm so sorry, Terry.
Okay, you get Social Security?
Yes.
Is her address on your Social Security checks and your Social
Mm.
Security paperwork?
No.
Okay, and you don't live with her,
Okay.
correct?
I haven't been able to leave in the last 5 years.
You have a house of your own?
No.
How come you have a different address on your driver's license then, ma'am?
I was staying with somebody else.
What address is on your driver's license?
1654 North 600 East.
Whose address is that?
A friend of mine's.
Okay, you don't stay there anymore?
Not really.
All right, ma'am.
I haven't been out of my daughter's house in the last 5 years.
Okay, well, Indiana law requires you to update your driver's license.
Okay.
You understand that?
Yes.
And you also probably should update your driver's or your address information with
Send her to
any
jail.
other agency who pays you money. I would suggest, but in any event,
Okay.
how many times has Mr. Hughes here driven by and flipped you off?
3 in the last 20 days.
Okay, you specifically, he flipped you off specifically.
Mm-hmm.
All right, and did he say anything along with that?
The day that they dropped off my phone, I can't remember exactly, but there was a video of it and a picture of it, but it was derogatory.
Well, what were the words?
Go F yourself and have a nice day.
Okay, when did he say that?
I think it was the 25th of March.
Okay,
And there was a police report about it, and the video was showing the policeman, and there's a picture.
well, why didn't you ask for a protective order?
Somebody has to get one because this is crazy.
Why didn't you ask for one though?
I have one at 1 o'clock.
You do against him?
Uh-huh.
Who's the judge on that?
I don't know.
Where is it?
On the 5th floor. I applied for it first because the police advised me to get a protection order.
Well, I wish you would have told him that this case was already here or that case was already there.
Well, that's what I was wondering about when she came in, if we could just, if we can get this protection order done or restrainer or whatever, if I'd have to go to the hearing at 1. Something needs to be in place to protect.
His hand is up, isn't it?
That's all.
Okay. So I see you have your hand up. Just give us a few minutes here.
My grandson's 6 years old. He doesn't understand.
Do you have any other questions for your mom or anything else you want her to tell me about?
No, not that I can think of, no.
Okay, Mr. Hughes, do you have any questions for this witness?
Yes, I do.
Go ahead, sir.
Okay, so the day that we dropped off your phone, I was parked in the street. Susie walked up to the door, set the phone down on the concrete, knocked on the door. Susie came back. We waited for her to open the door so she can get her phone and say that she didn't get it or whatever. She opened the door. I said, "There's your phone. Have a nice day."
Is there a question in the room somewhere with us? Are you going to ask a question, sir? Do you have questions for this witness?
Okay, yeah, I have a question. So you're saying that I drove by and flipped you off when Dylan was getting off of the bus. I did not do that.
Sir, is there a question in there?
I guess not.
But do you want to ask her that or you want to say that?
I want to ask her that.
Okay, well then ask it as a question.
All right. So you're saying I don't know if I'm going to say it right. So you're saying that I flipped you off when Dylan was getting off of the bus?
I told you there's videos.
That's a yes or no question, ma'am.
Yes.
That's not true, Your Honor.
So that's argument. I'll give you a time, but did you want to ask her any more questions?
No.
Okay. Do you have any follow-up questions you want to ask your mom?
No, sir.
Okay, thank you. I don't know what you'd be apologizing for. You can step down, be very careful. Please use my rail.
Take her to jail because she didn't change her driver's license. Handcuff her.
Okay, is there any further evidence you want to share with the court, ma'am?
No, sir.
All right. Mr. Hughes, what evidence would you like for me to consider, sir?
I've only been at that house 3 times in the last year. Once over the money that I loaned her for something and she's supposed to pay me back at tax return. And then about 6 months ago, my girlfriend had my car. I took my other car because my truck broke. I got home from work and I grabbed the wrong set of keys and I needed keys to get in my house. I called Lauren at work, said, hey, do you mind if I knock on the door and ask Susie for my keys? I knocked on the door, Susie gave my keys, I left. And then unfortunately, mid-January this year, my girlfriend had my car parked in her driveway. And since we want to talk about driveways, on 1602 and 1630 Poplar Street, where the houses are next door, 1630 is on the corner, and that's Pine Street. So 1630 has 2 driveways. One driveway facing west, and one driveway facing north. 90% of the time I go there, I come in the back way, come up Pine, and go into the back of the house. And now they want to talk about flipping off. So they have a camera in their window facing the back door of my girlfriend's and a good friend of my house. So yeah, when I walk up to the house, I flip the camera off. That's the only flipping off I do. I have not flipped off no 6-year-old kid or her mother.
Okay. Anything else you want me to consider?
No, that's it.
All right. Ma'am, is there any questions you want to ask him?
Every time I drive by my mean old lady neighbor, my middle finger gets Viagra syndrome.
Okay. Are these letters that you sent in from like Carol Allenberg and?
No. No, it's Carrie Allendorf.
Yeah.
They had wrote those statements for me.
Okay, so somebody filed these.
Yes, we filed them downstairs.
Okay.
So that way you would have them and that way there wasn't anything that had to be given to you.
And then there's 35 more pages of police reports and photos.
That's just between now and when I filed.
Okay, and that's not how evidence should come into a case like this.
I didn't.
Evidence has to be on paper and then presented to the court, so. But most of this stuff's hearsay anyway. All right.
I have a question.
Go ahead.
Can I ask her a question?
You can.
Okay, so I have a restraining order against her.
I'm aware.
Okay, so since that restraining order has been issued, have you been on 1630 property, on 1630 Poplar Street?
Have I been in the driveway? No.
Can I have a witness? Because she's not supposed to be at 1630 Poplar Street.
Well, this isn't the hearing where you try to prosecute some violation of the protective order.
Well, I'm just trying to get the truth and fact, not lies.
That's not what this case is about. This case is about her asking for a protective order against you.
All right.
Right. So if you have some sort of evidence that she violated a protective order that is in place against you, that's for the police.
It wouldn't do nothing.
Huh?
It wouldn't do nothing.
Okay. Well, I can't help you.
All right.
Yeah. All right. So this is a tough case for the court. And the reason it's tough, Ms. Bone, is because
No, it's not.
when I read,
She didn't prove shit. She lied. She was dodgy. Your
petition, right? Your petition talks about things that are a little bit heinous in a sense, because it talks about that you have been a victim of a sex offense, and that you are a person who has been physically harmed by Dennis Hughes. And none of the evidence that you presented to me today suggests that that's true. Okay, you also say stalking, but it appears that Mr. Hughes has some interest in the house next door. So if he drives by your house, I mean, it's a public street, he goes into that other driveway, he does what he has to do in that house. I mean, we can't really prevent him from doing that. So the only real compelling thing you have for me is the harassment. And a harassment is defined, okay, as repeated or continuing impermissible contact. And in order for it to be continuing and impermissible, it has to be of such a nature that it would cause a reasonable person to suffer emotional distress. And then there's a subjective part of that that would have to also specifically cause you emotional distress. Okay. So my problem is, firstly, it sounds like there's only one real incident of conduct where he comes by and flips you off. Okay. And then from my perspective, from an objective standpoint, that wouldn't significantly, it wouldn't be something, especially in your situation where you've got an ongoing like feud with this guy and you got this ongoing kind of malcontent between the two of you. Like that wouldn't rise to the level of something that should cause you emotional distress. And that's kind of course of business for you all. Okay. So from an objective standpoint, I don't think you meet your burden. And then subjectively, you told me some words that you think that the behavior is unnecessary, that you just want to be at peace, that you have a fear of him being around, and that you're worried about your son seeing this kind of negative influence. But I don't know that those are reasonable under the circumstances from an objective standpoint, okay? Impermissible contact would be him following or pursuing you, communicating, and the communication needs to be in writing, by phone, or through electronic means. I mean, we've all seen Top Gun. We know that somebody flipping somebody off at close range in an airplane high in the air is a form of communication. So, I mean, I think I can make the leap that it would be a form of communication, him flipping you off from a car. Now, the other ways that he could be contacting you would be through social media or through third parties, something like that. I just don't think you get there, okay? So I feel like you haven't met your burden, and I'm going to deny your petition. All right? Go ahead.
Sorry. He did contact my son's father and told him to tell me something while his restraining order was in place. Why would he have any contact or want to have any contact with me if he's in fear for his life of me? Why would he be telling him to tell me something?
Well, I don't know. What was the message?
That this is not going to go my way.
This protective order hearing?
Yeah.
Well, I mean, apparently he's some sort of prophet or some sort of...
Oh my God, he's psychic too.
I'm going to deny your petition.
And the judge is gone just like that. All right, guys. It was a bumpy one today, but it was okay. We made it through. We pulled through like professionals. And I don't know what's going to happen with Rebel. We're just going to have to read it on the internet, I guess. Sucks. But at least we got to see Sue in her glory, tearing apart oh no, you didn't get to see the guy that they, darn. Okay, listen. I need time because I have to download them all, but I'm going to download everything I have and I'm going to put it on my Patreon for free. So you go to my Patreon and you won't have to pay to watch. But I'll put everything over there that I got. So we can't do it on YouTube, but that doesn't mean we can't see the end of what I have. It'll be on Patreon, but I need time. And I work today, so you go to, yeah, Bren, take one for the team. And then we get to do your trial for contempt of court. We'll get to watch that. All right, guys, thanks for coming out. I appreciate it. I do. I shall see you 24 hours minus 2. And we learned what that word was yesterday, day before, but I forgot what it was already. Bye, guys. Thanks. See you soon.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.